Thank you very much for joining us. Those who are on the way will join us later. And we're starting the series of seminars, webinars related to effective protection and reconciliation. This 44 days war has demonstrated showed us that we live in a world where we are not protected at all. And this war was a violation of all forms of international laws in policy, that they were addressing the targeting civil population and the methods of running the war, bringing mercenaries, trafficking mercenaries into the war and putting them on the front line and on the weapons they used. And also it used methods of ethnic cleansing against tiny country Nagorno-Karabakh that was dreaming of building its own governance and own democratic state. Being for many years under the pressure of Soviet Union first and Azerbaijan, it kept its independence and kept its identity and its unique culture. But it's a really big destiny being surrounded by authoritarian regimes. Geographic destiny, when you are like an alien, when you want to build your society in a different way. And Artsakh and the Republic of Armenia were like that. Unfortunately, Artsakh were never been supported. The democratic movement of Artsakh have never been supported by democracies all over the world. And it has to fight its own way, building its governance on its own way. Democratic governance is, being surrounded by authoritarian regime also have been demonstrated during this war, when alliance of authoritarian systems have been fighting against this tiny country, cleansing, destroying monuments, uprooting people. More than 8,100 people have moved from their places, targeting children and humanitarian institutions. So this was against the people, against the people of Artsakh, and it was ethnic and cultural policy of cleansing. Another issue that was also, while trying to build its own democracy, at least after the first war, Artsakh has received its status, which was really a very weird status in international law, unrecognized state. What does it mean? People living in a country which is unrecognized. Do they have rights? How they are going to protect their rights if they're unrecognized? How they are going to raise their voices before the international community on their needs? And this status was providing quite very difficult, putting in a very difficult situation in Nagorno-Karabakh, when they didn't have a possibility to express themselves, to express their need. And the only way was through Armenia. And of course, the status also demonstrated itself, the insufficiency of the status demonstrated itself during this war as well, when no international agency, even UN, wanted to help Artsakh people, wanted to help refugees who were from Artsakh, because forced, UNICEF doesn't recognize children who were forcibly deported from their country, who were forcibly uprooted from their country. They are not refugees. They do not have definition. Who are these people? And it cost a lot of pressure, a lot of explanation in order for UN agencies to come and help. Velvet Revolution brought a new approach to Artsakh problem, inviting Artsakh to express their ideas, their thoughts, and being part of negotiations process, which was a very important process. But this war put back all of the achievements that have been with the Velvet Revolution and with the democratic movements. It is important to recognize the atrocities that have been taken place during this war, because what has happened is affront to international law, affront to democracy, and recognized little by little, they narrowed down the democratic space, making the space for people who dream for democracy, who dream for human rights, unable to express themselves, unpunished, such kind of crimes have tendency to return, to be repeated. So, and we all know, we all feel now that we feel bigger space. We need a bigger space for democracy now in the modern world. We feel the fragility of democratic processes. So this is, while we were discussing these issues, is to bring international community to understand the situation and to really react properly on what happened in Nagorno-Karabakh, and try jointly to build a new society that is built on respect of human rights, respect of people's will to build their own future. With that, I would like to demonstrate, I would like to speak about our panelists today. We have a group of distinguished panelists, and I would like to start with Mohammed Khelaifi, who is from Institute for Global Policy and also World Federalist Movement. And by the way, I would like to thank them that they supported the seminars for us. So he would be our first speaker, and he's a human rights lawyer, and he worked as program officer at this institute. Our second speaker is Evelina Ochap. I would like also to thank her for joining us today. She is co-establisher of Coalition for Genocide Response, a woman who has written wonderful, very important books on genocide. And also she is writing for Forbes magazine. Our third speaker is, as I said, Ombudsman of Artsakh, former Ombudsman of Artsakh. And we had in our list another speaker, Siranush, who was supposed to speak, Satya, who was supposed to speak today about exchange of hostages. But unfortunately, she had a problem, her personal problem last minute, and she had to travel to Moscow. But she will be on a second seminar, which it will be held on January 22nd, and we will inform you all additionally on this seminar. So without further ado, I would like to give the floor to Hamadi and start our discussion. Hamadi, floor is yours.
Thank you so much, Gulnara, for your invitation for this very interesting webinar. I'm so honored and happy to be here with you. I think what I will speak about today is international norm or term, which is the responsibility to protect. And this norm was or was mentioned a lot around the conflict, like the war on, in Armenia, and the conflict between Azerbaijan and Armenia is way bigger than that. I would not go a lot in depth on this term because it has a lot of complications, a lot of details. I will just try to relate it to the ongoing conflict and war that is happening now. And I mean, unfortunately, to the failure of international community into at least applying it or invoking it when it comes to the case of Armenia since at least 30 years. So I will go ahead and share my screen with you. I think I'm not able to share my screen. You can activate that, Gulnara, if you can. But if you cannot, it's
just
okay.
A minute.
Oh, great.
Yes, please.
Yes, now I can do that. Thank you. So I have this small presentation. Just one second, I find it here. There we go. First, I wanted to talk about R2P as a concept, like what is R2P and why it was mentioned by scholars a lot when it comes to the situation in the war, maybe on the state of Artsakh and the whole conflict in Armenia. The responsibility to protect is actually known as R2P, which is an abbreviation used a lot. it's not a law. A lot of people think it's a law, like it's a part of international legislation. It is not. It's more like a political engagement made by like United Nations member states, and like create it or like acknowledge it in the World Summit in 2005. It's an international norm that seeks to ensure that like the international community never again fails to hold the mass atrocity crimes of genocide, war crimes, ethnic cleansing, and crimes against humanity. So we're talking about 4 crimes here under the umbrella of R2P. When like we have to like bring R2P to the table, it's when one of among these 4 crimes occur. So the concept emerged in response to the failure of the international community to adequately respond to mass atrocities committed in Rwanda in the 90s and then former Yugoslavia during the 90s as well. So the International Committee on Intervention in State Sovereignty developed the concept of R2P during 2001 in Canada. The African Union also adopted that in 2002, and then like the world or the World Summit in 2005 adopted resolutions about R2P as like a norm that like defines it as like the responsibility of the state as like one state and the international community to protect civilians from these 4 crimes that I have mentioned. Actually, the R2P is based on 3 pillars. When like what is happening now that there are a lot of stereotypes, maybe if I'm using the right word, or a lot of misconceptions about the R2P, that the responsibility to protect equals international community intervening by the military. This is not the case. R2P is way bigger than that as a norm and a concept. It's based on 3 pillars. The pillar 1 is that every state has the responsibility to protect its population from mass atrocity crimes, the 4 crimes that I mentioned: genocide, war crimes, crimes against humanity, and ethnic cleansing. So the first responsibility to protect is actually by the state itself. The state has a responsibility to not allow mass atrocities, crimes from happening on its territories. It doesn't matter if it's like if it's against its own citizens or internally displaced people or refugees. Any person, a human being who's present on its the territories should not be subjected to this like mass atrocities crimes. So the first pillar is the country itself. And this is how like the international law has moved historically when it comes to the concept of sovereignty that is always used against the application of R2P. Whenever like the international community tried to stop mass atrocities, the like authorities or like people who are committing crimes will, the first thing that will say, we're a sovereign country, you cannot intervene here. We have our total sovereignty. But the international law switched that into using the sovereignty as a responsibility and not a privilege. So if you have your sovereignty, you have a responsibility within that to protect your own, like people who are in your country from mass atrocities. And it's not just a privilege that you use and you can do whatever you want in that like particular country. The pillar 2 of R2P is that the wider international community has the responsibility to encourage and assist individual states in meeting that responsibility, which means that international community will not always use arms and like its military force or like use violence to stop mass atrocities. The first thing is that assisting or helping these countries, if they're willing to stop atrocities, like by means of diplomacy, sometimes if they're not willing to do that by pressure, by economic sanctions, they have to move to step 2 of R2P before going to pillar 3 that we have seen sometimes happening, which is if a state is manifestly failing to protect its populations, the international community must be prepared to take appropriate collective action in a timely and decisive manner in accordance with the UN Charter. Here with the UN Charter, we mean Article 6, that is talking about the decisive and timely manner. By decisive and timely, it means that it is not occupying other countries and staying there. It is having a timely action that will stop mass atrocities, and it doesn't go beyond that. I mean, I know that what I'm saying is being criticized by a lot of scholars when it comes especially to the example of of Libya in 2011, when a lot of scholars said that the application of R2P, like that actually stopped thousands of people from dying or from being victims by a decisive and timely action that was like limited in time, did not succeed because you need more assistance. You need to be with you need to assist the countries to rebuild itself, to not allow mass atrocities from happening again. You need to have further assistance, and this is one from probably maybe of the critics on R2P. And what I want to say here that R2P is a new norm. It emerged in 2005 and is still evolving and developing when it comes to what happens after having an intervention, or what happens after taking action to protect civilians from mass atrocity crimes. So here is what I have mentioned previously, that R2P has been invoked in more than 80 UN Security Council resolutions concerning Central African Republic, Cote d'Ivoire, Democratic Republic of the Congo, Libya, Mali, Syria, and the responsibility to protect has also been invoked in more than 50 human rights resolutions and 30 General Assembly resolutions. So since 2005, the term R2P has been used more and more a lot by international institutions and by the UN, in different bodies. And its applications also evolved. It succeeded in countries like Kenya in 2007. It did not succeed for 100% in countries like Libya, but it is still evolving as a new international law norm that creates this obligation for everyone, for the international community, to protect civilians in the world. Here comes the R2P in the case of Armenia, or also the case of state of Arabah, and that is pretty complicated and honestly unique when it comes to talking about the application of R2P, or trying to establish a link between R2P and what is happening in state of Arabah or in Armenia. So what is happening now, I'm sure that you know more than me, you have a lot of details, but to sum up and to establish a link with R2P, that Azerbaijan armed force combined with Turkish-backed jihadists from other countries like Syria and Libya attacked Artsakh or Nagorno-Karabakh department on September 2020, and more than 2,300 or even more Armenians, including civilians, have died as a result of the Azerbaijan aggression. The failure of diplomacy and the international community in willingness to protect civilians opened space for other countries like Russia and Azerbaijan, as a country in front, to oppose an agreement that authorized Russian peacekeepers to be there. And I'm quoting peacekeepers here because with reserve. So the events in Artsakh are another example of the international community's failure to protect humanity, to protect civilians. And we can see how dangerous is the honestly stigmatization, or the not giving an importance to the norm of R2P as an obligation on the international community to protect civilians. This failure from the international community to respond to the 4 crimes of genocide, ethnic cleansing, war crimes, and crimes against humanity, particularly in the cases of former Yugoslavia and Rwanda, precipitated the development of the responsibility to protect norm, as I mentioned, in 2001 and then 2005. But the problem here, and the biggest issue, and even on a personal opinion, I would say that R2P unfortunately only works when UN member states, especially permanent members of the UN Security Council, are prepared to enforce it. So here comes also the political whim, unfortunately, of state members and permanent powerful countries who own this privilege of using the veto. I can mention the sample example of that Russia and China have vetoed the application of R2P in Syria 17 times in the Security Council. They have always vetoed any humanitarian intervention or any humanitarian action to stop the mass atrocities against civilians who are dying in Syria, for example. So this is why we have seen a lot of critics why R2P has been applied in 48 hours in Libya, but never in Syria. Why we're not even talking about protecting civilians and protecting people in Artsakh, in why is R2P not brought into the table in the Security Council? So here comes, unfortunately, like the political willingness, the political whim, whether they decide to enforce this important norm, protective norm or not. I want to also talk about the situation after September 2020 in Artsakh, or in Armenia as a whole, like in relationship with R2P, and not like gonna analyze the whole political situation or the war situation because it's very complicated. Like, because this latest stage of reinvigorated debate on whether the narrative of remedial secession must be incorporated into the conflict resolution process was steered like by former president with reference to the Geneva Municipal Council in 2020, which actually acknowledged self-determination as the only way to ensure the safety. But it's, as Gulnara said, a very ambiguous and not clear status at all. After that, like when we are trying to draw preliminary conclusions about whether there is any new space to employ R2P and remedial secession language, we have actually to address 4 sets of factors, which need to be expanded further in the future as Azerbaijan and provoked military aggression is well established. First is the scale of civilian casualties and destruction of infrastructure. We still do not have enough data about that, and I don't know why. Like there is all this ambiguity about like collecting data. I'm sure if like all the data is collected, we'll have shocking numbers about deaths. Second is war crimes and our intent to commit such crimes. We'll all know that it's happening, but the need for documentation or for gathering evidence is very important. It's even crucial here. 3 is interim status and peacekeeping operation, and 4, recognition of the state of Artsakh. Like the recognition and having clear status is very important here. First, has like there been any significant destruction and discriminate of fire of civilian infrastructure and non-combat casualties in Nagorno-Karabakh that can be independently verified by international institutions? This needs to happen first. There is no doubt that like the authorities in Nagorno-Karabakh have already gathered enough evidence of this, and cooperating with the international community on it will be very important. So the answer is yes for like number 1. Second, when it comes to the Azerbaijani troops, did they with or without direct command commit war crimes during the armed hostilities? The answer here seems is definitely also yes, that the Azerbaijani leadership can be established with like relative ease, that they actually ordered that. And there are even names of like, I can mention, for example, of Muammar Gaddafi, that it was the intent of this colonel that warred in 2 resolutions in 2011, an intervention in Libya, but unfortunately it was a poor execution of which led to the current situation and the current hesitation regarding the application of R2P international politics. There are people even who are mentioning other people as war criminals now, as like Ilham Aliyev, and it seems that there is a little doubt about this in the international community, while Turkish leadership has aided and abated the commission of these crimes. So we can here quote Article 16 of draft Articles of State Responsibility. So Aliyev's and the Azerbaijani rule international energy security is artificially inflated primarily by the media, experts on their payroll, and politicians shall not be too hard to credibly establish with a calculator in hand. It would be very easy to do that. The ICC here, the International Criminal Court, that plays a crucial role here as well. But unfortunately, Armenia, nor Azerbaijan are members yet, was finally given jurisdiction in 2017 to review cases about the crime of aggression. So that can be also employed when it comes to the situation in Artsakh. After the battlefield is cleared, most probably other war crimes will also be well documented, as I mentioned beforehand. So here, third, and in other ethnic conflicts in Kosovo, for example, Remedial secession and the latter declaration of independence were preceded by the establishment of the United Nations Interim Administration Mission in Kosovo. I think this also needs to happen in Artsakh. Pursuant to Security Council Resolution number 1244 in 1999, it's unknown at this stage whether the basic principles of 2007, or any of latter iterations that contain provisions of interim status will change or are going to remain on the table. The ceasefire arrangement released on the form of press statement by the foreign affairs ministers of Russia, Armenia, Azerbaijan, October 10, doesn't provide any clarity on this. One argument can be that in contrast in other conflicts, including Kosovo, Nagorno-Karabakh Republic has resilient state institutions, a democratic form of government and laws, holds regular elections, and thus any interim status will be downshift, let alone alien to the local realities. Whether any robust peacekeeping operation will be dispatched at this point in time also remains unknown. Whether there's going to be actually an application of R2P in like a strong application out of Port one, like what happened in Libya. It's only clear that the past behavior of Aliyev regime does not give high hopes for any respect in the this R2P principle, and that ceasefire violations, if not another war, are imminent. And given the geopolitics of the region, it's a good guess that consent-based peacekeeping forces at some stage are going to be dispatched. The source of their legitimacy should be international institutions, not just a country sending their troops like Russia did. Here I'm talking about the UNSC, the OSCE, or hot coalition or an unilateral arrangement, as well as their mandate must consider the long list of past failures of the application of R2P in other countries. And like the successful models, like for example, what happened in Kenya in 2007. And to speculate further here, such an arrangement can also be based on the high-level Vienna arrangement and after like the aftermath of 2016 April War. So here, finally, like the fourth point, Armenian Prime Minister Nikol Pashinyan has called upon the international community, and particularly France, in the last interviews to recognize the Republic of Artsakh as a measure to prevent humanitarian catastrophe. It must be flagged that the recognition of states as inherently political, not just a legal act. So this is why probably a lot of countries are hesitating here. So finally, I would like to say that the events in Artsakh reveal the limitations of R2P as a concept to protect, even though it's very important, and we should always like not give up or like not go with the narrative of that application of R2P is impossible because only due to political whim or political willingness or political agenda. I think what's happening in Artsakh also reveal the indispensable role of the international community in providing moral and political leadership. And the victims of aggression by Azerbaijan and Turkey are paying the price of these failures. So I think that we need a strong political leadership in the Security Council to evoke that and to respect like this international norm and when it comes to the situation in Artsakh. I think I'm done with my short presentation. I would like to thank you. And if you have any questions, actually, you can go ahead and ask me like in the chat section, or maybe you'll ask me directly. I'll be happy to do that. Thank you.
Thank you very much, Amadi. I think we will keep the questions by the end of the session, when also, Ombudsman will join us, because it would be very interesting also discussion. Thank you very much. You really covered a very, very important issue for Armenia and Artsakh. Our next speaker will be Evelina Ochap. Evelina, the floor is yours.
Thank you very much, Gulnara. Thank you very much for organizing this important session on the topic of effective prevention and reconciliation, starting with recognition and punishment of the crime against humanity. And indeed, I would like to cover those two topics: recognition of atrocities for what they are, and punishment of those atrocities. And this will be mostly in relation to the work that we are doing here in the UK on the topic of genocide. And I shall start with the topic of recognition. And mass atrocities must be recognized for what they are, full stop. There is no discussion about it. However, instead of focusing on the crime against humanity, I would like to talk about the example of genocide, and why it is important to recognize mass atrocities as genocide, and what such a determination means. What are we talking about when we talk about genocide determination? Of course, we could talk, there could be a determination of genocide for the purposes of individual criminal responsibility or state responsibility, which of course needs to be done by competent courts, whether domestic courts or international courts, depending really on the case, what we are looking into. However, before that, there is a need for an interim determination of mass atrocities for what they are, for the purposes of state informing its responses to such mass atrocities. And this is exactly what I'll be referring to as genocide determination. And again, genocide determination should not be confused or conflated with the determination of such atrocities by courts. And again, for example, for the purposes of individual criminal responsibility. The analysis and the determination discussed by me here will be the interim determination made by states to inform their responses only. And the UN Convention on the Prevention and Punishment of the Crime of Genocide, the Genocide Convention, does not make it clear that state parties should conduct their own genocide determination. It is just not mentioned there. It talks about the duties, the duty to prevent, the duty to punish the crime of genocide. However, the fact that according to the International Court of Justice, the duty to prevent is triggered when the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed, ultimately means that the state should have effective monitoring and determination or analysis mechanisms in place. Where states do not have such monitoring and determination mechanisms, they may easily rely on the argument of the lack of relevant knowledge, and so avail themselves of responsibility. And this is, of course, contrary to the duty to prevent, as discussed by the International Court of Justice in the case of Bosnia, and also against the spirit of the Genocide Convention. Conversely, another question would be, who else can make such a determination of genocide? Several states have argued that it is for international judicial systems to make such a determination of genocide, and indeed the UK is one of those states. However, this argument is flawed because it neglects the basic fact that it is the state that is a duty bearer under the Genocide Convention. Hence, the states that are parties to the Genocide Convention must act to ensure that such a determination is made by a competent body and in accordance with their laws, with their policies, and of course, that follow-up actions are taken, whether decisive steps to fulfill the state's obligations under the Genocide Convention to prevent and punish or suppress the atrocities. Also, the reliance on the international judicial bodies neglects the issue that often there will be no such international bodies that will be able to engage with the question. The UN established investigative mechanisms, ad hoc tribunals, or the ICC are the main international bodies most relevant to the question of genocide determination. And historically, it was the UN Security Council, despite being reluctant to deal with the question of genocide determination, but has undertaken steps to ensure that such a determination is made. For example, in the cases of mass atrocities in Bosnia and Rwanda, the UN Security Council established a commission of experts to examine and analyze the evidence of the atrocities and confirm whether the atrocities amount to the crime of genocide. And once the committees of experts confirmed their findings, the UN Security Council then proceeded to establish ad hoc tribunals to deal with prosecutions of the perpetrators. This, of course, changed with the creation of the ICC, the International Criminal Court, that Hamid already mentioned briefly. And the ICC was established to remove the burden of requesting and overseeing the investigations and prosecution of international crimes by the UN Security Council. However, of course, the ICC is a treaty-bound court and its jurisdiction is limited. And I will mention a little bit more about that later on. Another international judicial system that could deal with the question of genocide determination is the International Court of Justice. However, to do so, it would have to be approached by one of relevant organs, for example, the UN General Assembly, the UN Security Council, or other competent organs or specialized agencies. The ICJ could also be approached by states, And of course, we know just recently, the Gambia approached the ICC with a case and filed a case against Myanmar. Unfortunately, this has not been used very often. And the determination and recognition of mass atrocities for what they are is not a matter of good practice only, and derives from states' international law duties, and is part of the duty to prevent and punish of the crime of genocide. And as Gregory Stanton, former research professor in genocide studies and prevention at George Mason University, conducted a study on the perception and effects of using the words ethnic cleansing and genocide. And his research notes that recognizing mass atrocities that meet the legal definition of genocide as genocide has resulted in more comprehensive response, including responses to stop the atrocities. Referring to such crimes as ethnic cleansing did not have the same effect. As such, empirical reality suggests that there is a difference in the way different international crimes are being addressed by states because of the way we determine them. And genocide determination also plays an important role in addressing the issue of genocide denialism, namely the act of denying the occurrence of genocide that is aimed at denying justice to the victims and belittling their suffering. And of course, over the years, we've seen many cases of genocide denialism. And of course, I focus on the case of genocide and explain why we need to recognize atrocities, mass atrocities as genocide for what they are and use the word genocide. Of course, the word should not be used lightly, and genocide has a very precise legal definition, and that legal definition is in Article 2 of the Genocide Convention. And the same in relation to recognizing mass atrocities for what they are applies also to crimes against humanity and war crimes. And those crimes have the legal definition in, for example, the Rome Statute. So that would be Article 7 and 8 of the Rome Statute. And whenever we talk about genocide determination or mass atrocity determination, we have to compare such atrocities and analyze them against the legal definitions of those atrocities, whether, as I mentioned, Article 2 of the Genocide Convention, or for example, in cases of crimes against humanity, war crimes, Article 7 and Article 8 of the Rome Statute. However, also for the purposes of genocide determination, and as I mentioned, the judgment of the International Court of Justice in the case of Bosnia, it is not only about determining genocide mass atrocities as they are being perpetrated or as they have been perpetrated. States also need to focus on the risk of such atrocities. And I cited the judgment from the ICJ that talks about the state having to trigger the duty to prevent when they see a serious risk of genocide. And as such, of course, there's a great need to ensure that states monitor the atrocities and monitor the early warning signs or risk factors. And for example, the UN produced a great framework for the analysis of mass atrocities, and this framework for the analysis of mass atrocities is not only it's not only for genocide, but it's also for crimes against humanity and war crimes, and it identifies those different risk factors for all mass atrocities, but then also focusing specifically on the different international crimes, and it is a very important framework for any kind of analysis, and should be adopted by all states for their own monitoring, for their own analysis and determination of those atrocities. And initially I wanted to also briefly mention responsibility to protect, but of course it has been already very well covered by Hamadi, so I will not be covering it and covering the topic. And I would like to talk also about the prosecution, punishment of mass atrocities, and starting, of course, with some of the models from previous years. And of course, such international crimes as genocide, crimes against humanity, and war crimes must be duly investigated and prosecuted, whether by domestic courts and international tribunals. But if we look at previous years, and if we look at various mass atrocities happening around the world, we know that such atrocities are pretty much neglected by whether domestic or international courts, and there are many reasons for the different failures. In terms of international tribunals, of course, the International Criminal Court is the only permanent criminal tribunal out there. However, it is a treaty-bound tribunal, and as such, its jurisdiction over the situation in the territories or persons are dependent whether the state is a party to the Rome Statute. If the state is not a party to the Rome Statute, the ICC doesn't have the necessary jurisdiction to engage. However, there are other ways how to engage the ICC. And for example, one of the options is for the UN Security Council to refer a situation to the ICC. And this has been done twice. And that was once in the case of Darfur, and the second case that was Libya. Hamadi also mentioned that a number of resolutions in the case of Syria were blocked by, for example, Russia at the UN Security Council. And he mentioned mostly humanitarian resolutions. But ultimately, there was a resolution back in 2014 that would refer the situation in Syria to the ICC. And so if that resolution was successful, the ICC would then have the jurisdiction to deal with the issue. However, back then in 2014, that resolution was blocked by China and Russia. And unfortunately, ever since, there have been no similar attempt to refer the situation in Syria to the ICC. And despite the fact that, of course, over the subsequent years, 2014, 2015, we've seen the Daesh atrocities perpetrated against religious minorities in Syria and Iraq that could be classified as genocide. There have been no attempt to try again and refer the situation, whether in Syria or the situation in Iraq, to the ICC. Another option, of course, would be another option to engage international tribunals would be, for example, for the UN Security Council to actually establish ad hoc tribunals. So rather than relying on the ICC with the very limited jurisdiction, the UN Security Council could itself establish ad hoc tribunals. And the ICC has done that in the past, for example, in the cases of Bosnia and Rwanda that I already mentioned. So the UN Security Council took two-step approach. The first step was to establish a commission of experts to collect the evidence, to make the determination of the atrocities as genocide. And then the second step was for the UN Security Council to establish ad hoc tribunals that would deal with the prosecutions. And this is how we had the ICTY, ICTR that would deal with the issue. Again, it appears that this legacy of the UN Security Council appears to be forgotten now. And one of the reasons is that, of course, with the establishment of the ICC was meant to be the body to deal with all those prosecutions, to take this burden from the UN Security Council. However, the main limitation is that the ICC is a treaty-bound court. So unfortunately, this is the main limitation there. And just briefly, in relation to the ICC, there is yet another option how, for example, the ICC could get involved in certain cases, but it has not been used that often. So the other option for the ICC's engagement is actually referring a state party to the ICC. And just looking at previous cases, this option has been used mostly for so-called self-referrals. So states referring themselves to the ICC. And I will just mention very briefly one interesting example, and that's the example of Palestine. So of course, the statehood of Palestine has been questioned for a very long time, and a few years ago, the UN General Assembly recognized the statehood of Palestine. And after that, Palestine approached the ICC and asked to become a party to the Rome Statute. And that was approved. Palestine became a state party to the ICC. And after that, Palestine self-referred itself to the ICC, which is basically asked the ICC to investigate the atrocities within the territory of Palestine. And some some may think that that's a crazy idea to ask the ICC to investigate the crimes in Palestine, because ultimately it means that the ICC can look into any kind of atrocities perpetrated by Palestine. But ultimately what it also means is that the ICC can look into the atrocities perpetrated by Israel in the territory of Palestine. And this is precisely why various states have resorted to this approach of self-referral, to basically not to allow the ICC to investigate the atrocities that the country perpetrated, by to enable the ICC to look into the atrocities perpetrated by others within the territory of that state, which is a very clever way of using this self-referral. So these are just few options in terms of the ICC and in terms of also UN Security Council establishing ad hoc tribunals. But of course, we cannot forget that apart from the international tribunals, apart from the international options, of course, states can prosecute such mass atrocities. And I mentioned the Genocide Convention. Of course, the Genocide Convention includes a duty to punish the crime of genocide. What it ultimately means is that state parties to the Genocide Convention had to introduce laws criminalizing genocide within the domestic criminal law. And of course, as such, states can prosecute their own citizens for the crime of genocide in many countries, and of course states that are parties to the Rome Statute, they also introduced criminal laws criminalizing other international crimes, whether crime against humanity, war crime, or crime against aggression. So again, states can use their domestic courts for such prosecutions. But states can also prosecute foreigners for crimes perpetrated abroad, based on the principle of universal jurisdiction. And many states have been resorting to the universal jurisdiction to prosecute perpetrators for crimes perpetrated abroad. And one of the recent examples of a very great use of the universal jurisdiction is a case from Germany. In Germany, the German criminal courts prosecuted Daesh fighters, Iraqi Daesh fighters, for genocide perpetrated against the Yazidis. And in that case, it was an Iraqi national who has never lived in Germany, perpetrated the atrocities in Iraq, but nonetheless, because of the principle of universal jurisdiction, the German domestic criminal courts were able to prosecute the atrocities. And German courts have been very proactive with dealing with especially Daesh atrocities. As we know that, of course, right now there is no international tribunal to prosecute Daesh fighters for their atrocities against Yazidis, Christians, and others. There have been some attempts to establish such ad hoc tribunal. Unfortunately, all those discussions now stopped. So we definitely need more domestic courts prosecuting the perpetrators and ensuring that, well, the Daesh fighters don't get away with genocide. And of course, Germany is not the only country that has been exercising universal jurisdiction to ensure that victims see some justice being done in their lifetimes. There are many countries that have been proactive. However, it is still not enough. Comparing the number of the mass atrocities that we've seen over the recent years, there need to be more and more such attempts to ensure justice for the victims and survivors. So I would just summarize some of those points. So of course, I've been discussing the importance of determination of mass atrocities. And this is important, and especially the interim determination of mass atrocities for what they are is important specifically for states to inform their responses to, for example, suppress the atrocities, but also to prevent them from materializing, especially in the case of genocide. And then, of course, whether to provide humanitarian assistance or any kind of assistance to the targeted communities. And it is also important in terms of thinking about ensuring justice for the victims. And indeed, all atrocities, all mass atrocities must be investigated and prosecuted. And there are many ways of doing that. And of course, I mentioned a number of international options, a number of domestic options. But ultimately, we cannot have a situation that if you speed even 10 kilometers above the limit, you'll be prosecuted. But then if you perpetrate mass atrocities, you won't be prosecuted for such atrocities. We cannot have such a situation. We need to make sure that mass atrocities, and especially mass atrocities such as genocide that aim the annihilation of a protected group in whole or in part, duly investigated and prosecuted. So this is something that we need to focus more on. We need to ensure that states work together towards this aim, because ultimately, if we don't prosecute, if we don't punish the perpetrators, we'll see more similar atrocities happening in the future. A crime begets further crime. So I think I will stop here, but of course, if there are any questions, I'm very happy to answer.
Thank you very much, Evelina. It was very, very comprehensive presentation and covered almost all the, if we had, all the questions. Very, very, thank you very much. I'll give the floor now to our next speaker, and then we will go up to the questions. Our next speaker is Artak Beglarian, and first of all, a former ombudsman of Nagorno-Karabakh, of Republic of Nagorno-Karabakh, and I want to congratulate him with his new position. As a Chief of Staff of Prime Minister, but also express my sorry that as a human rights defender, he was really the best. He did enormous work, and when Hamadi was speaking about documenting all atrocities, he has done huge work in documenting each case and has published a very important reports based on facts. So thank you very much, Artak, and floor is yours.
Thank you, Mrs. Shahinian. Thanks for this opportunity and for the introduction. I want to understand what topics I should cover, whether I should speak about all the atrocities in general, or certain types of atrocities are much more interesting to the audience. Please.
I think all atrocities, if it is possible.
Right.
Okay. Because we are going to have a next sessions where we separately would be going deeply into each atrocities.
All right. Then it will be general overview.
Okay, thank you.
All right. Firstly, I guess everyone knows the background, the general background, that since September 27, Azerbaijan and Turkey started large-scale war against Karabakh, and it took 44 days, and it was quite intensive and aggressive war, and there are lots of atrocities by Azerbaijan, by Turkey, and by mercenaries involved by Azerbaijan for support of Turkey. Those atrocities included very regularly, systematically, and intensively targeting civilian population, civilian objects, critical infrastructure, objects under special protection of international humanitarian law, such as cathedrals, schools, kindergartens, hospitals, ambulances, rescue service, etc. Targeting journalists, using banned methods and banned weapons, such as cluster munition, terror-inspiring means, chemical weapons, white phosphorus, etc. Engagement of mercenaries and terroristic groups, and many types of inhuman treatment cases, including torturing, mutilation, beheading, willful killing, etc. And there are many evidence and proofs on all of those crimes and atrocities. And our analysis shows that all of them, that many of them have been deliberate. I mean, targeting civilians and civilian objects. In some cases, for sure, there are indiscriminate cases. But they had systematic and organized and deliberate nature in general. And one of the basic reasons or ground of those atrocities is long-term xenophobic anti-Armenian hatred policy or Armenophobic policy in Azerbaijan for many years. And the impunity of previous crimes, including those happened in 2016 during 2016 war, 4-day war, and which have been also documented by us, by Artsakh Human Rights Ombudsman, but there was no punishment by the international community. And also another reason or another context ground for these atrocities or for the intensivity or aggressiveness of those atrocities is absence of international community in our country, and over 100% isolation, international isolation of the country and of our people, which was pushed by Azerbaijan, but agreed and accepted by the international community with the argument that we are a recognized state. But without considering the fact that the human rights conventions and human rights principles say that political, legal, or any kind of status of any territory should not be a reason for human rights violations. And that's why I always say that international community bears responsibility for those atrocities, because the presence of international community would prevent many, many crimes here, but unfortunately it didn't. And by now we see that the isolation of our people continues, and the international community accepts the rules and blackmails of Azerbaijan, and by now no organization except for ICRC, no international organization, doesn't work here. UN somewhat, it seems, that has the intention, has the purpose to come here, but Azerbaijan doesn't allow, or there are many political issues, and including the Council of Europe and UN monitoring bodies by now have not visited Artsakh for fact-finding missions. Coming to some statistics and some details of those atrocities. Firstly, I would mention that more than 70% of our communities and over 90% of our population in general have been targeted during the war. Targeted by rockets, missiles, shelling, airstrikes, including by drones, striking drones, suicide drones, etc. And I'm not talking about the invasion and occupation by the Azerbaijani forces and their consequences. For example, burning houses, destroying buildings, cultural heritage, etc. I'm talking only about the war consequences themselves. All the densely populated areas and communities have been aggressively and intensively targeted by rockets and ballistic missiles, including capital city Stepanakert. In the beginning, we had many casualties, but since it was quite dangerous and unpredictable, we had a large number of displaced persons, civilians, just in the beginning. And more than 70% of our population, more than 100,000 of the population have been displaced by the end of war to the Republic of Armenia because of these dangers. And by now we have recorded over 65 civilians killed. Among them, 40 of them have been killed as a result of targeting civilian objects and civilian population in distance, let's say, remotely by a rocket shelling, aviation bombardment, etc. 25 of them under their control as civilian internees captured persons or forcibly disappeared persons. These 25 cases, the majority of them, we have the bodies. In some cases, we have video evidence. For example, beheading videos. But still, we have over 35 civilians missing. Some of them, we are sure, are captured, are imprisoned, though they are not formally, officially confirmed by Azerbaijan and by ICRC, but we have the proofs. But unfortunately, we are also sure that the killed civilians are much more than 65, and hopefully we'll find their bodies. Almost all the bodies that we have returned or we have found have signs of mutilation, tortures, beheading, etc. And now there are investigations by our legal bodies. And we also, the Human Rights Ombudsman staff also documented many crimes, including based on our fact-finding mission from open sources and also not public open sources, including interviews, etc. There are many cases of targeting schools, kindergartens, hospitals. In many cases, we have sufficient basis to say that there were deliberate targeting. For example, targeting the cathedral, Ghazan-Chechotsk Cathedral in Shushi on October 8, twice on the same day, with remotely controlled missiles. Based on our analysis, it was by a striking drone. It means that it was highly accurate strike, and it was deliberate strike, because on the same day, in 4 hours, It was, they struck this cathedral on the same place twice. And during the first strike, there were civilians in the basement of the cathedral, women, children, elderly, and one day prior to that strike, on October 7, there was a media report coverage and interview from this group, civilians group, who said that we are living here, we are staying here because we think that cathedral is not dangerous, is a safe place for us. It means that striking the cathedral, they had the intention not only to strike our Christian identity, but also to make panic among civilians to think that no place, nowhere is safe in Karabakh in order to leave the country. And during the second strike, there were journalists inside the cathedral, foreign Russian free journalists who have been injured. And the Armenian journalists who witnessed that moment, they said that there was a drone flying over the cathedral, which means that the entrance of these journalists to the cathedral was visible for the Azerbaijani forces. There is another case how they targeted the maternity and child medical center, central center hospital in Stepanakert with highly accurate missile again. They targeted also the hospitals in Martakert, another town of Karabakh, for a few times. There are tens of cases, many evidences and witnesses that they targeted ambulances. Tens of cases we have killed doctors and wounded soldiers in ambulances with Red Cross signs. But again, at the battlefields, they just since the beginning, they targeted with shelling, artillery, and with suicide drones these ambulances. And schools, kindergartens also have been targeted or indiscriminately distracted or destroyed. Another type of atrocities is targeting journalists. I said about the cathedral case. There was also another case in Martuni on October 1st that a few groups of foreign and Armenian journalists in downtown Martuni was targeted by Azerbaijani shelling under live watching or controlling of reconnaissance drones, which means that they saw that it was civilian place, there was no military object nearby, and there were journalists working there with distinctive signs and with cameras. And 2 French journalists were injured heavily, and 2 Armenian journalists have been wounded, and an Armenian local guy was killed who was accompanying this journalistic group. This was for sure a deliberate targeting of journalists. And after this case, the Azerbaijani Foreign Ministry made a statement demanding all foreign journalists to leave Karabakh and not to enter Karabakh without the Azerbaijani permission. This statement also showed the intent of targeting journalists, especially foreign journalists, in order to make panic among them and to leave the country because they saw that the foreign journalists are independently covering the war crimes by Azerbaijan and Turkey, and they needed to prevent objective and independent monitoring and coverage, even by international media. That's why they decided to target especially foreign journalists. Another type, as I said, is use of banned methods and banned weapons. There are many, many cases proved that they used cluster munitions against civilian objects and civilian population. For sure, all of us know that it's not 100% banned weapon, but it's banned by customary international law. I mean, I would say that it's already a rule of customary international law. And especially when they use these cluster munitions against civilian areas, densely populated areas. And because of that, we had many wounded and killed civilians because of these cluster munitions. They used very extensively wide area effect weapons, explosive missiles, rockets, while targeting both military and also civilian objects, and also critical infrastructure at the center of Stepanakert and in other communities, because of which we have by now very serious infrastructural issues. And during the war, we had serious problems, deprivations of electricity, gas, water, telecommunication, etc., etc. And the humanitarian disaster was deeper because of this targeting critical infrastructure, including mostly with wide area effect weapons. And many casualties among civilians happened also because of this use of this kind of weapons, because in many cases they targeted residential buildings. And fortunately, in many cases, those buildings were empty or people were staying at the basements and shelters, and the casualties are not too large in proportionality in comparison with the extent and intensivity of targeting civilian areas. Also, they used chemical weapons. We have published a special report on this this crime, but after publishing the report together with the Armenian Ombudsman, we had found much more proofs, and now we are continuing the fact-finding mission on this too. And hopefully in the upcoming period, we'll have more detailed and more professional reports on this, that they used white phosphorus against, in many cases, against our combatants, against our soldiers, and also against our forests in order to burn the forests and to have better positions, let's say, in these forest areas. And more than 2,000 hectares have been burned because of use of these chemical weapons. And we have hundreds of cases already that doctors said detected wounded soldiers by chemical weapons, very likely, mostly there were phosphorus, white phosphorus. Coming to inhuman treatment cases, I would say that the most brutal part is this one, because there are hundreds of videos and photos on social media proudly published by the Azerbaijani forces, but I think there are much more cases which have not been videoed or have not been published on social media. And together with the Armenian Ombudsman, we prepared 6 non-public reports on these inhuman treatment cases and gave all the details, including photos, videos, identities, whatever we have, to show how the Azerbaijani forces inhumanly treated both prisoners of wars, civilians, but also the dead bodies. And there are many cases that how they killed, willfully killed, beheaded Armenian POWs or civilians. There are much more cases. They are showing the inhuman treatment against of POWs or civilians, I mean captured alive, but also the dead bodies, mutilation of dead bodies, cutting of the ears, noses, taking of the eyes, beating them, insulting them, etc. And we documented those crimes. In some cases, the identities of perpetrators are visible, but in most of cases, the perpetrators are quite careful, because it seems that they understand very well that it's crime. That's why they hide their identity. But for sure, there are criminal cases and investigations on those crimes. And our analysis, as I said, show that those crimes have systematic nature, and they are encouraged by the society and by the Azerbaijani government. Because the more brutal the videos are or crimes are, the more encouraging or welcoming the reaction of the Azerbaijani social media users are. And also there is silence by the Azerbaijani government and the prosecutor office, or in some cases they say that it's fake video. Though there are international investigations, including by Bellingcat, by Guardian, by Reuters, BBC, etc., on some videos, some photos, or some cases, showing that they are not fake. But also I mean the 2 ombudsman offices, made analysis, and we also detected all the cases which are not fake, including with technical methods. We did our best to have professional and without propaganda fact-finding mission and research. And hopefully the international community will give proper reaction, including punishment to those war crimes. At least to prevent new war crimes, both here and in other places, in other areas of the world. Because for prevention, punishment is a must. Coming to another type of crime, I would say that it's already common knowledge that there are thousands of mercenaries fighting in Azerbaijan, because there are lots of international media publications, but also many statements by great powers leadership. Russian, American, French, German, Iranian, etc., including presidents, foreign ministers, heads of their intelligence services, etc. There are different numbers mentioned by them, but it seems, based on our analysis and our intelligence services facts, it seems that there were at least 4,000 or 5,000 mercenaries overall fought in Azerbaijan through support of Turkey. And these mercenaries also have been engaged in mass atrocities. There are some videos, they are talking, or they are witnessing what kind of commands they have. For example, we have two mercenaries captured by us, by our forces, and two of them confirmed that the Azerbaijani commanders promised them not only monthly salary, but also promised $100 per each Armenian head. It means that the Azerbaijani government encouraged beheading by mercenaries too, beheading of Armenians. Actually, that's all. If you are interested in more details, I'm ready to answer your questions.
Thank you very much. It was very comprehensive coverage of all these, unfortunately, atrocities that have been committed during this war. Now, floor is open to questions. Identify yourself.
Can I have a question?
Yep.
I have actually two questions. The first one is to Ms. Ocap concerning the ICC involvement, and you mentioned about the ways how ICC can be involved to investigate cases of mass atrocities in different territories and countries. You brought up an example of Palestine, and I'm interested in that because despite the fact that Palestine is non-member, it's like non-member observer state, has non-member observer state at the United Nations. In case of Artsakh, Artsakh does not have any recognition by the UN. And can you please specify in case of Artsakh whether this kind of procedure can take place? I mean,
okay, yes.
Like self-assessment, like invitation done from in case of Artsakh.
Okay. Yes, and so of course that would definitely be very difficult for the ICC to engage, because the ICC, one has to be a state to become a party to the Rome Statute to then be subject to the ICC's jurisdiction. With Palestine, the story was relatively long, because of course for a very long time Palestine's statehood has been denied, and of course, as I mentioned, it's an observer to the UN. And before the recent decision that the ICC can get involved, and before the Palestine becoming a member to the ICC, Palestine applied to the ICC twice and was rejected twice. But that was after the UN General Assembly recognized Palestine as an observer. That's when the progress, everything moved, and that's when Palestine applied to the ICC again. That's when that application was approved. So unfortunately, I think a lot would have to happen. So even for Artsakh to be recognized as an observer to the UN, I think that would be possibly the first step. Unfortunately, the path will be long, and of course there's a lot of political will involved there as well. But other option could be potentially looking into the option of referring the atrocities to the ICC. Again, this is very difficult. It is very difficult to involve all states, and from recent statements, it looks like, for example, China would highly likely veto any kind of referral to the ICC just as a matter of principle. And of course, the US has been having a very difficult relationship with the ICC. Although there is no suggestion that the US would veto any such attempt. However, I think it would be worth looking into the support among the members to the Security Council, support for such a resolution referring the situation to the ICC. However, apart from engaging the ICC, I think it's worth looking into ensuring that there is a monitoring mechanism, a UN monitoring mechanism specifically for the situation. So, for example, such monitoring mechanisms have been established in the past. For example, for North Korea, and there've been one for Myanmar, of course, for Syria, and for other situations. And the benefits of having such a mechanism in place is to ensure that at least the evidence will be collected and preserved and prepared for future prosecutions. And very briefly, I will mention as well, in my presentation, I mentioned the struggles of any kind of actions and resolutions passing the UN Security Council. And also I mentioned the resolution that was meant to refer the situation in Syria to the ICC. And because of the stagnation at the UN Security Council, a very proactive step was taken by the UN General Assembly. And the UN General Assembly passed a resolution establishing the IIIM, so Independent International Impartial Mechanism for Syria, that basically collects the evidence of the atrocities, preserves this evidence for future prosecutions. So of course, at this stage, it is very unlikely that of course this situation will be considered by the ICC. There is no ad hoc tribunal to prosecute the perpetrators, but at least the evidence will be collected, and if the situation changes, if there's political will, for example, at the UN Security Council to proceed with such a resolution, then the evidence will be ready.
Thank you.
Anna, do you have another question? Or thank you very much. I'll pass the floor to Sosita Titian. I see a question.
Thank you very much. I would like to thank all the speakers for amazing presentations. And I have some relevant previous background because I worked in the UN missions in East Timor and also Central African Republic during the war. And I also worked in OSCE and UN missions in Kosovo when it became independence. And that's why I wrote an article about remedial right application to Artsakh and gave an interview, and I shared it here if you are interested. But I would like to ask a couple of questions that are still not clear to me. So basically, apparently, there is not a huge number of civilians being killed during the last war. So the official number is 65. We assume that it's much more. However, still it's not like thousands. And so is it a problem? But what I'm trying to say is that apparently there was a genocidal intent by Azerbaijan, because it started targeting indiscriminately civilian areas of Nagorno-Karabakh. And the only reason that there are no civilian, many thousands of civilian deaths, is that because the population was evacuated. And even before that, they were in bomb shelters, because I believe that people, authorities and people in Nagorno-Karabakh always expected a war. So they were kind of prepared in terms of bomb shelters, etc. But they were apparently many displaced, several tens of thousands displaced. And the intent was clear. The intent that Azerbaijan was using all kinds of sophisticated armaments, cluster bombs, Smerch, etc., in residential areas. So is the intent enough for considering it an attempt of ethnic cleansing or not? That would be my first question. And my second question would be about ICC. I was actually very sad to hear what I just heard from Evelina, that China may veto any resolution where ICC is mentioned, because since we are not a member of ICC, apparently a Security Council resolution could be one of few ways to address this issue to ICC. And we also suspect that there may be an issue with United Kingdom, because UK has been traditionally considered a country that may not allow consensus on Nagorno-Karabakh related resolutions in the Security Council. So is there any other way? You mentioned Gambia, by the way. This is another country I worked 2 years ago. And yeah, Gambia demonstrated very interesting commitment to human rights, actually applying to ICC for the case of Myanmar Rohingya. So I wonder, what is the mechanism that Armenia or Nagorno-Karabakh could actually use to make this case to ICC, given the lack of membership, and also given what you just said about China and possible other reluctance by other Security Council permanent members? Thank you very much.
Yeah, so that's a lot of different questions. And just maybe I'll start with the first question that you mentioned about, of course, the relatively small number of deaths. And I think I think that I covered the topic a little bit about the duty to prevent and what the ICJ said in the case of Bosnia about the duty to prevent. So of course, with the duty to prevent we don't have to wait until we see thousands of bodies lying on the streets. And actually we don't necessarily have to see bodies at all. What the judgment says is that the duty to prevent is supposed to be triggered when the state learns of the serious risk of genocide being perpetrated. So I think theoretically that could be when the plans for genocide are being perpetrated. When the plans for genocide are being prepared. I think that's already when the duty theoretically should be triggered. So we definitely should not wait until we see more and more bodies on the street. So I think if we take the duty to prevent seriously, we should analyze the risk factors. And I mentioned the framework for the analysis of mass atrocities. And if you look at that framework, some of the risk factors are, for example, previous mass atrocities or previous genocide or international crimes that have not been investigated, that have not been prosecuted. It is one of the factors. So of course, this has to be taken seriously. And there are many other factors, for example, specifically targeted at an ethnic or religious community. This is also one of the factors that has to be taken into consideration. Specific intent historically has been one of the most difficult elements of genocide to prove. But of course, it's not only about individuals saying that, yes, we want to annihilate a protected group in whole or in part. You can infer the specific intent from the atrocities as well. So of course, all those elements will have to be considered, and an analysis would have to be, a proper analysis would have to be done of the situation. In the case of the ICC, of course, I don't want to be too negative, but of course I don't want to give too much hope as well. But it's been challenging and at the ICC and get the at the UN Security Council and get the support from the members at the UN Security Council. And of course, all you need for a resolution is 9 votes in favor, but you cannot have any vetoes. And the 5 permanent members have the veto right, and of course that can bury any resolution. I mentioned China mostly because China made some statements over recent months that they would not support the engagement of the ICC, where the ICC doesn't have the jurisdiction, from what I remember. And of course, Russia in the past has also made similar statements. The UK, I don't think that the UK would veto, maybe they would not support, but I don't think that the UK would veto such a resolution. But I think the main problems would be China and Russia. These are the 2 countries that I would mostly worry about in terms of vetoing such a resolution. But ultimately, I think what would need to happen, without me just wondering who would potentially veto or reject such a resolution, I think it would be worth looking really and discussing that with the different representations, whether there is any political will to proceed with such a resolution. And you mentioned the ICJ and the Gambia case. Of course, ICJ is different from the ICC, so the ICJ would not be able to prosecute the perpetrators. The ICJ could ultimately deal with the question whether there is any kind of breach of the UN Convention on the Prevention and Punishment of the Crime of Genocide. So exactly as it is right now with Gambia and Myanmar. So Gambia asked a number of questions in relation to Myanmar being in breach of the UN Convention on the Prevention and Punishment of the Crime of Genocide. It would be worth looking into the option. Ultimately, well, both Armenia and Azerbaijan are parties to the Genocide Convention. I think it would be worth looking whether they made any kind of reservation when acceding to the convention that could prevent any further steps. So I think that would be the next step to look into any kind of reservations made by the countries. And of course, in the case of Gambia, Myanmar, Gambia was very brave and proceeded with the case on its own. But later, Gambia was supported also by Canada, the Netherlands, and I think yet another country. So of course, it would be worth also looking whether there are any other states willing to support, for example, Armenia with such a step. Ultimately, it would not have to be Armenia to proceed before the ICJ. It could be any other country. So I think, again, it's very important to look into the support that could be given towards this potential action.
Thank you so much.
Are there any other questions?
Yes,
Okay.
I have.
Yeah, please.
Why the Azerbaijani people was in silence, and the Azerbaijani government didn't speak about the war and in the front. After the war's over, our Armenian government said that Azerbaijan was won in front, and Azerbaijani government didn't say to Azerbaijani people that they won, and the medium was locked. Why it was?
Mm-hmm. Whom you are addressing the question, Zaven? Zaven? Zaven?
What?
Do you hear me? Whom you are addressing the question? Zaven, do you hear me?
Already, yes. I hear you.
Yeah. Okay. Whom are you addressing your question?
I don't know. It isn't correct question. who can answer my question.
Artak, would you pick up the question or, yeah, okay, thank you.
I guess yes, but if you repeat, because I didn't get the question.
Yeah,
Last part.
me too.
I was asking about the Azerbaijani government. My question was that why the Azerbaijani government was in silent about the war in front. The media of Azerbaijani government was locked, and why it was happening.
Mhm.
You mean why they kept silence, or?
Yes.
Or why they locked the media?
Why the Azerbaijani government did all that?
Right. If I understood correctly, I will answer. Actually, the Azerbaijani government is an authoritarian regime. And not only during the war, but also before the war, it was authoritarian, including regarding with media relations. I mean, for a few years already, I guess since 2017, there is a law there that no news without permission of government or non-official news from frontline or from army cannot be published anywhere, including social media. And there are criminal cases and punishment cases because of such kind of news, and uncontrolled news, I mean. And it means that Azerbaijan was getting prepared for war, including in this field, in order to control the information domestically, and in order to hide the losses during the war, not to affect negatively the mood of Azerbaijani society because of the losses, and to keep control over the risks. But also they wanted to close all the channels for the Armenian news, for the Armenian official or non-official news to the Azerbaijani society, in order to keep them out of Armenian information control. Even they banned, the Azerbaijani government banned social media there, for example, Facebook, and the Azerbaijani users used Facebook with VPN, which gave an opportunity for the Azerbaijani government to avoid ads. I mean, by Armenian media, ads to the Azerbaijani audience. And there are many other ways that the Azerbaijani government did in order to control the information over the society. Did I answer, or I got wrongly?
Yes, you answered.
Right.
Thank you very much. Are there any other questions? If not, maybe I will thank the panelists, and if they have, we have a couple of minutes. If they have something to add, we can add, but I would like to thank everyone also for their really high expertise and time they provided to the seminar. And I'm sure that we'll translate this also for Armenian audience, and this will be widely shared with permission of the panelists. And as I said, there will be a series of such webinars, and we will inform you on the dates and themes, and those who will be interested are welcome to join us. Thank you very much to all for this really, really very rich discussions.
Thank you.
Thank you.
Thank you.